Hello, everybody. Just before we start our webinar, I have a brief question. Can you hear me? And can you get a picture of us? Would you please write down in the chat room to confirm this? Otherwise, if you experience any difficulties or technical problems, please let us know as well, and we will try to fix it immediately. Okay, I can see that I have a very good connection and I can get a feedback from you. Let's go ahead. Our webinar is dedicated to the latest developments and trends in the Russian trademark law and practice. And it will be held by myself, Alexey Kratiuk, and my colleague, Viacheslav Rybchak. We are both trademark attorneys working for Gorodissky and Partners. We've been associated with this firm for many years now, and I believe we have very good experience in trademark matters. And we would like to share our thoughts regarding trademark developments in Russia with you, and we really hope you will find them interesting for your practice. So it's high time to start our presentation, and the first question to be touched upon concerns obvious advantages of electronic filing in Russia. And I'm giving the floor to my colleague Viacheslav Rybchak, who will provide more details on this particular issue.
So hello to everybody. We start with the topic about electronic filing of trademark applications. So as you know, for several years already, the Russian PTO provides for a possibility of electronic filing of trademark applications. The number of applications filed electronically permanently increases. So in 2016, there were more than 18,000 trademark applications filed electronically in Russia. Such electronic filing has real advantages in comparison with paper filing, and it goes without saying that it provides the possibility of paperless work, and it makes more comfortable and more attractive for trademark holders in comparison with paperwork. It should be also noted that when you file applications or documents with the Russian PTO electronically, so this happens instantly, so you have not to spend time on delivering documents to the Russian PTO, which is very comfortable. And should be also noted that electronic filing of applications or documents with the Russian PTO is possible around the clock without interrupting the procedure for weekends or for holidays. And also an important moment is that by filing an application electronically, the official fee for filing application is reduced by 15%. So you should be aware that by filing an application in Russia, you have to pay an official fee for filing application and formal examination and an official fee for substantive examination. So in case you file electronically, the official fee for filing and formal examination will be reduced by 15%. Now we go further with a general overview of the trademark proceedings in Russia. It should be noted that in the year 2015, some regulatory acts were adopted and entered into force in Russia, and which regulate in details the trademark prosecution. These are administrative regulation, the rules for drafting, filing, and considering of documents, and the requirements to such documents. All these papers now regulate in details all aspects of trademark prosecution in Russia. In particular, the administrative regulation provides that the overall term for trademark proceedings in Russia, starting with filing application and including examination and issuance of the trademark certificate, constitutes 18 months and 2 weeks. This term can be increased in case some additional submissions or documents are required from the applicant, and the Russian PTO has to check these documents. So, as you can see on this scheme, a trademark application in Russia undergoes a formal examination and a substantive examination. According to the new adopted regulations, the formal examination in Russia takes 1 month, counting from the date of, counting from the moment of confirmation of payment of an official fee for filing application. And the substantive examination constitutes 12 months maximum. In case the examiner requires some additional documents from the applicant, so it forwards an official inquiry with 3 months term for responding, and the applicant may also extend this term for 6 months maximum. It should be also noted that now the terms for considering the applicant's responses to official actions are also regulated by new acts. So the applicant's response to an official inquiry now is considered within 1 month maximum by the PTO. In case the Russian PTO finds some bars to registration, so it forwards a so-named official notification about the results of examination, or in other words, a provisional refusal action. And the applicant has 6 months for responding to this official document. In case of filing of a response, the examiner will have 2 months for considering the applicant's arguments. So I think we go further.
So what's about possibility of objections during examination in Russia? Since October 1st, 2014, all the applications are to be published in Russia, and all the information and materials pertaining to such applications can be disclosed to third parties upon their request. Therefore, we have to be very careful in terms of submission of any kind of evidence or documents in support of applications, because such materials may become open for inspection by third parties. Just after the publication date and before the issuance of a final decision on an application, any person, not only interested one, is entitled to file the so-called written observations against an application while it remains pending, just to try to prevent such an application from being accepted. The observations can be filed on absolute or relative grounds or both. And the claims set out in such observations are to be taken into account by the Russian PTO when conducting examination.
The Russian Civil Code provides for the possibility of any person to get familiarized with materials of a trademark application after its filing. Since 2015, in Russia, there are administrative regulations specifically dedicated to the procedure of requesting the materials of a trademark application. According to these rules, the materials of a trademark application can be requested by any person. But it should be noted that these provisions apply to the applications filed after the 1st of October 2014, and namely from the date from which the Russian PTO started to publish all filed applications. So accordingly, any person may get familiarized with the materials of a trademark application by requesting a personal visit to the Russian PTO or by requesting copies of materials. In case of requesting copies of materials, these are provided by the Russian PTO within 30 working days, and also upon payment of a respective official fee. The term of 30 working days can be increased in case the application materials are located in the remote place of storage of the Russian PTO. In this respect, it should be noted that actually all materials of a trademark application can be accessible to third parties. This can be, for example, copies of any official documents forwarded by the PTO to the applicant, or this can be copies of responses filed by the applicant with the Russian PTO, including all enclosures. This can be also copies of written observations filed by any person against the trademark application. So the above should be kept in mind, especially if you file with the Russian PTO some documents relating to your commercial activity and which may have confidential character. So please be aware that now all these materials are accessible to third parties.
Now some words about classification requirements. It goes without saying that when filing an application, you have to describe the list of goods and services for which the trademark protection is being sought. And the specification of goods and services has to be made using very clear and unambiguous wordings reflecting the exact nature of those goods and services. In Russia, the scope of protection in respect of trademarks is defined by the trademark name itself, as well as the list of goods covered by the mark. And therefore, it is imperative that, and highly recommendable, that the specification of goods should primarily cover those goods for which the mark is intended to be used in Russia. On the other hand, the specification of goods should be adequately broad to make it possible to effectively combat possible infringement by third parties. When filing an application, it is possible to claim class heading, the list of specific goods above, class heading and the list of specific goods. The latter option is more preferable in many cases because it allows to obtain broader scope of protection and emphasize protection for the most important goods, for the goods which are most important for the applicant at the same time. Duplication of terms is not allowed. It means one and the same term cannot be repeated more than once in the applied specification. The duplicated terms have to be deleted. And finally, in some cases, we deal with the situations where a product name may enjoy protection as a geographical indication or an appellation of origin in some jurisdictions. It's quite common for the spirits brands. For example, whiskey brands, such as, for instance, Scotch whiskey name. And I must say that according to the latest practice of the Russian PTO, such wordings are not acceptable at all. Even though the applicant manages to obtain some kind of permission from a competent authority, for instance, a letter of consent from Scotch Whisky Association confirming his right to register the brand in respect of such particular goods, it will not work in Russia. And therefore, it is strongly recommendable to use just generic names instead of those names which incorporate some kind of geographical indications. For example, it's better to use the name whiskey instead of Scotch whiskey in order to avoid possible inquiries on part of the Russian PTO. Now I would like to let you know the latest trends in respect of registration of realistic depictions of products as trademarks in Russia. Generally speaking, realistic depictions of products may not be registered for those products, especially if the shape of the product is functional. The shape is functional when it is required to achieve a particular technical result. However, if the design and the shape of the product is quite original, is quite unique, it may not automatically result in the protection being granted. It has to be established what those original design solutions are, whether these are perceived by consumers as a means of individualization, that is to say, perform a trademark function, or whether it is all about aesthetic features of a product. I mean, artistic and construction solution, which defines the outer appearance of a product. In the latter case, such designations may not be registered, as this may be deemed to be inherently non-distinctive. And the only option to get them registered is to prove that such a designation has acquired necessary distinctiveness or secondary meaning in Russia. The acquired distinctiveness must be documentarily proved, and the evidence of acquired distinctiveness should reflect intensive and long-standing use of the designation in Russia before the priority date. Here you can see some examples from the most recent practice in Russia concerning registration of realistic depictions of products as trademarks. On top of the right-hand side of the slide, you can see a realistic depiction of a dried crust. It was applied for registration in the Class 30, and this particular mark was refused protection based on lack of distinctiveness, as the shape and design of the product was found quite typical and mostly functional for such kind of goods. In the middle of the same part of the slide, you can see a realistic depiction of a smartphone. It was applied for registration in Class 9, and it was this case was unsuccessful either. The mark was refused protection based on the same ground, lack of distinctiveness, as the shape and design of the product was found to be typical for the market. The applicant tried to overcome such a refusal by arguing that the proposed design solution featured some original design elements, including rhyme, slots, and icons, which were depicted on the mark, on the image of the mark. However, the Russian PTO considered such an argument to be insufficient, not to be persuasive, because those additional original design elements were simply not visible as compared with the rest of the elements of the applied composition. And the mark was totally refused protection in Russia. On the bottom of the same part of the slide, you can see a realistic depiction of a group of jewelry items composed of the earring and rings. And this mark was refused protection based on lack of distinctiveness either, despite the fact that the design of the product was very unique and recognizable by consumers, which was proved by numerous awards and quality certificates issued in connection with this product. The Russian PTO simply considered those design solutions those design solutions are all about aesthetic features of the product, that they simply characterize the product itself rather than trademark. In other words, it was considered that the proposed original design solutions were necessary just to perform a static and decorative function rather than trademark function, and therefore could not be taken into consideration by the Russian PTO. And the refusal decision was issued as a result of examination of such application. On the right-hand side, on top of the right-hand side, you can see a realistic depiction of a suite. Although the shape and design of this product is quite typical for the market, this mark was, however, allowed to proceed to grant based on acquired distinctiveness. In the middle, you can see a realistic depiction of a biscuit. This particular mark was successfully accepted without any objections being raised on part of the Russian PTO, as the design and the shape of the product was recognized to be unique for such kind of goods. And finally, on the bottom of the slide, you can see an ice cream label which incorporates a realistic depiction of the ice cream. This particular label was accepted for registration with the disclaimer of the realistic depiction of the ice cream. The mark was protected as a whole. Now I would like to let you know some fresh requirements concerning the representation of three-dimensional marks in Russia. Recently, the Russian PTO has issued a recommendation note as to how to correctly depict and describe three-dimensional objects which are thought to be protected as trademarks in Russia. The recommendations suggest that when filing an application to register such a trademark, we're supposed to submit all the relevant views of the three-dimensional mark, especially general view, which help to understand the nature and all the essential features of the object. All the images are to be made in the same technique, whether realistic, photographic, schematic, or others. It's quite important that all the significant details which are capable of influence the overall impression of the object are to be expressly mentioned and reflected on the images of the mark which we file in support of the application. Why it is so important? I'm going to illustrate this by referring to one interesting case from the recent practice. On the right-hand side, you can see a tablet, the design of the tablet, which was applied for registration in class 9, and this particular mark was refused protection in Russia because the design and the shape of the tablet was found quite typical and mostly functional for such kind of communication devices. The applicant was trying to overcome such refusal by pointing out to the fact that the proposed design solution featured some original design elements, especially smooth transition of the back side of the product from the flat shape into flattened ellipse. Although this design solution is in fact unique and original, what makes the whole object, the whole design very recognizable and eye-catching for consumers, this very important detail was simply disregarded by the registry because it was not reflected on the images of the mark that formed a part of the application, and therefore they could not be taken into consideration when conducting the examination. Now I would like to discuss some new trends in terms of recognition of trademarks to be well known in Russia. But first of all, before we go ahead with this, I would like to just give you a brief background what we understand under the well-known marks in Russia. In Russia, all the designations, regardless of whether these are registered or otherwise protected, or instead are used in Russia without any such protection, may be recognized well-known. In order for a trademark to become well-known, it has to meet certain requirements. The first one is that it should be distinctive. Secondly, the brand owner must demonstrate intensive use of its mark, especially in Russia, and the use must be so intensive as to create a tight link between the brand name, particular trader, and specific goods in the consumer's mind. In order to obtain well-known status of the mark in Russia, you have to apply for recognition of a trademark to be well-known by way of filing a special application, which has to be considered by the Russian BTO. And when filing an application, you have to indicate the date at which the trademark became well-known in Russia. It is imperative that such date should predate priority date of any confusingly similar marks owned by third parties in relation to similar goods. Until recently, the Russian PTO was guided by the rules for consideration of the rules for recognition of trademarks to be well known, which were quite tough in terms of possible amendments. And since October 2015, the administrative procedure for recognition of trademarks as well known has undergone significant changes. In particular, it is now possible to amend the mark. It makes sense when the mark, which was intensively used in Russia, is slightly different from the one which was registered. Such amendments are acceptable, subject to the fact that they do not affect distinctive features of the mark. In other words, the amendments are acceptable if they are not essential. The consideration of the application for recognition of the well-known mark is now, the term of consideration is now strictly limited to 10 months. Whereas in previous times there was no such requirement at all. During consideration of the application for recognition of your trademark to be well known, it's possible to specify the claims. For instance, it's possible to specify the scope of protection by limiting the list of goods for which the trademark is being recognized to be well known. It may be required in a situation where you do not have the sufficient evidence of intensive use for all of the applied goods, just for a part of them. In such case, the specification of goods for which the mark is being recognized to be well known may be limited to just those goods for which you have sufficient evidence of intensive use. And finally, it is now possible to amend the date at which the mark became well known in Russia. It makes sense in a situation where the brand owner feels that he will have much better evidence of intensive use by the amended date rather than by the original date. These were new trends in terms of consideration of well-known applications in Russia, and let's go ahead.
So now a few words about the Russian PTO's initiative, which is actually very actively discussed in Russia between IP specialists, attorneys, state bodies, all interested persons. I mean the possibility of introduction of an opposition procedure in Russia like it exists in many other countries. So this project is proposed for discussion by the Russian PTO, and it provides for the following stages of trademark prosecution. So after filing, a trademark application undergoes a formal examination within 1 month. After that, within 3 months, the examiner verifies whether some absolute grounds can be applicable to the claimed designation. In case there are no problems, so the Russian PTO is supposed to publish the information about the positive results of the examination. And starting from this point, any interested person will be able to file within 3 months an opposition. In case an opposition is filed, so a 6 months term will be granted to parties in order to settle the matter. In case the dispute between the parties is not resolved within this period of 6 months, so the matter is decided by the Russian PTO based on the available materials, based on the opposition materials. This project is discussed, and it's not certain whether it will be accepted or not, because there are supporters and there are opponents. This project has its advantages and also disadvantages. Among positive aspects, the Russian PTO insists that introduction of such an opposition procedure would result in a reduction of time frames for trademark prosecution. Furthermore, it's supposed that an official fee for examination will be reduced because the Russian PTO will no more check third parties' rights. Furthermore, introduction of an opposition procedure probably and to some extent will allow avoiding the examiner's subjectivity in determining the similarity between conflicting designations. However, on the other hand, introduction of such an opposition procedure would result in the necessity for trademark holders to permanently monitor the database and timely file oppositions in case some similar trademark is revealed, and thus incur respective expenses. Furthermore, introduction of an opposition procedure and the absence of checking of third parties' prior rights by the PTO may result in an increased number of so-named low-quality registrations, and as a consequence, in an increased number of IP disputes, which will have to be resolved by the PTO in frames of administrative proceedings or by the IP court. And furthermore, there is still a risk of misuse of this opposition procedure by unfair persons, for example, by persons who may file a great number of applications for similar trademarks, and thus the trademark holders will be obliged to file respective oppositions. Or such unfair persons may just file oppositions against existing applications on any ground, using any ground, just to impede registration. Summarizing the above, I can say that introduction of an opposition procedure still have reasons for further court discussions between all interested parties. Now, at the end of our presentation, also a few words about another topic regarding the Eurasian trademark. As you know, Russia is a member of the Eurasian Economic Union, comprising also such member states as Armenia, Belarus, Kazakhstan, and Kyrgyzstan for the time being. And within the frames of this organization, the member states discuss the possibility of introduction of Eurasian trademark system and operations origin system, like it exists in Europe, a community trademark system. This, in perspective, this will be an option for trademark holders for obtaining trademark rights on the territory of all member states by filing one single application. So in case such Eurasian trademark system is introduced, an applicant, a trademark holder, will be able to file in one single application and with no requirements to have a basic application or basic registration in place. Among main features of this Eurasian trademark system, I can name also the principle of the regional principle of exhaustion of trademark rights, and also the principle of recognizing the valid use of a trademark on the territory of the whole Eurasian Economic Union in case the trademark is used only on the territory of one member state. The introduction of the Eurasian trademark system is actually on the final stage of consultations between all member states, and I must say that the Russian government in February of this year already approved a respective agreement on trademark, service marks, and operations of origin by adopting a specific administrative regulation. So we will inform you about further developments regarding introduction of such Eurasian trademark systems, as well as about any other developments that will occur in Russia.
Well, I can still have a question from Melissa Norton. And the question is as follows. What happens if the terms of consideration pass without registration? Do the rules allow for automatic registration or abandonment? I must say that the Russian law does not allow for automatic registration or abandonment in case the terms of consideration pass without registration. The Russian law does not contain any sanctions for such kind of actions. In the meantime, if we talk about international marks, as you may know, we have a very limited period of time within which examination could be conducted. In Russia, this time limit is 12 months, and if the Russian video does not object, does not raise any objections against an application within this period of time, then the mark is supposed to be granted protection in Russia automatically. But this criteria does not work in respect of national application. And the administrative regulations which refer to a specific time limit for consideration of the application should be treated as some kind of guidelines for the Russian examiner, which does not actually contain any sanctions for the breach of this rule. Any other questions?
Yeah, any other questions? In any case, if you have some questions, you can just write to the email address you can see on the screen, and we will respond in best delays.
Mm-hmm.
So we have a question about the slides. Will the slides be available after the webinar? I think we will be able to forward to you the slides without no problem.
Concerning the previous question, yes, I would like to confirm that it is just approximate.
So, okay, if you would like to have slides, you can write to us, and we will send them upon your request. We have a question about the Eurasian trademark. If I correctly understand your question, you ask about whether other member states can enter this Eurasian Economic Union. As you know, we have also the Eurasian Patent Convention, and for the time being, not all members of this Eurasian Patent Convention are members of the Eurasian Economic Union, and it's supposed that these members will also join the Eurasian Economic Union in the future. So the Eurasian Economic Union is opened for all interested countries, and they are welcome.
Okay. Any other questions? Yes,
we have a question about the confidential information that can be filed with the Russian PTO. I can just say that actually the situation is that any person may have access to all materials that are available in the trademark application in the Russian PTO. So there is no possibility to hide some documents. This is the requirement of the Russian legislation in force.
All the application, all the materials and any kind of evidence that we file in support of an application cannot be kept confidential any longer. So any person is entitled to get acquainted with all the materials pertaining to such an application. We have a question from JDPI. What kind of evidence would be considered most influential in consideration of a FAME declaration? If I get it right, you mean what kind of evidence we normally submit in support of the fame of the mark, in support of the fact that the mark has acquired distinctiveness in Russia. Well, if I get it right, then I would like to say that there is no specific list of documents or evidence which should be submitted in support of the application, in support of the fame of the mark. Normally, the evidence, as I said during our presentation, should reflect long-term and intensive use of the mark, especially in Russia. This could be confirmed by for example, shipment documents by different agreements accompanied with the evidence of their performance, with the survey results, with information about publication of the information about the product in the Russian media. It may be confirmed by advertising and promotional materials, etc., etc. The list is unlimited. So whatever you believe to be most relevant in a particular situation, you can submit. to the Russian PTO in support of the fact that the mark has obtained secondary meaning in Russia. And all these materials and evidence are to be considered by the Russian PTO. And if the Russian PTO finds them to be persuasive, then it is supposed to consider the mark as having acquired necessary distinctiveness, what makes it possible for the mark to be eligible for protection.
And we have a further question from Anita about the introduction of the acquisition procedure. This is not launched yet. This is only discussed, actually. And the future will show whether this will be accepted in the form it is discussed now, or maybe it will be changed. Because, as I already said, this project proposed by the Russian PTO has supporters and also opponents, because there are many advantages and many disadvantages for this procedure. So this is only discussed now, and in case there will be some changes in trademark prosecution, we will be able to inform you accordingly.
So if there are no other questions, I would like to thank all of you for your very kind attention. And I would also like to draw your attention to the fact that a team of our IP professionals will be attending the interconference this year in Barcelona. And should you like, we can arrange a meeting to discuss these and other possible issues concerning trademark practice in Russia and CIS countries. Should you like to arrange a meeting, just please write down to our general email address, and we'll try to arrange it.
So thank you for everybody. Thank you to everybody. I think we can now close our meeting. So thank you for being with us this evening.
Thank you.